Welcome back, everybody, to the Florida Appellate Review Case Law Update. I am here with Jennifer Dinetz at Clark Fountain, La Vista, Prather, and Licky Rubin. Our other co-host, Jeff Edelman, he's away on a much-needed family vacation up in South Carolina this week, so we miss him very much, and we will see him again next week. For this week's Case Law Update, we're going to discuss three different cases, civil cases in our areas of specialty, personal injury, torts, and the like. Two of those, we're returning back to our theme of improper misconduct down at the trial court level. And then our third case is a much talked about issue, the boarding of past medical bills, and a case certified up to the Florida Supreme Court. So good morning, good afternoon, Jen. How are you?
Great. Excited to jump in, especially with these boardable cases, because it's a very hot topic.
Definitely so. So I'm going to start off, and this was a case from the 4th District, R.J. Reynolds Tobacco and Philip Morris versus MAF Foods, if I'm pronouncing it correctly. Now, this is an Engle progeny case, and this again is a situation where the 4th District criticized the plaintiff's trial counsel. This is the 6th case that this trial firm has been unfortunately criticized for improper closing arguments. In this case, it did result in a new trial to the tobacco defendants in comparison to a case from the 4th District the week before, where the 4th District had criticized similar closing arguments, but had held the error was the closing arguments were harmless in the prior case. In this particular case, MAF Foods, there was numerous objections raised in closing argument, and I won't go through all of the closing argument comments, but one of them, plaintiff's counsel called Philip Morris a soulless enterprise of death. The trial court did overrule that objection. And then later during closing argument, plaintiff's counsel read from George Orwell's novel 1984, and plaintiff's counsel did compare the tobacco companies to Big Brother as the totalitarian state that can, quote, monitor everybody. And then plaintiff's counsel read a passage from the novel to the jury. And on appeal, the 4th District agreed with the tobacco defendants that plaintiff's counsel had presented the passage to equate the tobacco companies with Big Brother, and that the jury needed to save the decedent, the smoker's memory, with a large verdict. And as the 4th District noted, the passage had no connection to the evidence. And in fact, the court noted the identical passage had been read in the prior Engle case from the 4th District, R.J. Reynolds versus Kaplan. And so just as the comments were improper in the Kaplan case, the 4th District, the panel here, again held that the opinions or that the closing argument was improper. Now, in this case, there were other areas of improper closing argument beyond 1984. There were no Nazi references this time, or Holocaust references or implications.
Losing his touch.
There was a reference to Oscar Wilde's Dorian Gray, a discussion about that. Dorian Gray in the book is a playboy in Victorian England, and then goes on to describe that. The tobacco companies objected to those arguments. The trial court overruled some objections. There was another closing argument where plaintiff's counsel stated tobacco companies were, quote, rotten to the core. Personally, I think the evidence supports that, but nonetheless, in the context of closing argument, the appellate court did not think that that was a phrase which should be used. And then finally, plaintiff's counsel told the jury not to lose sight of the evil that men do. Plaintiff's counsel continued by stating that the conduct of these individuals lives on. Horrors leave shadows, especially carcinogenic horrors. And then you can't plunge the spear all the way straight through their heart. They have to feel it through. The trial court did sustain that particular objection at the end there. And so,
I like that imagery, though.
Yeah. And so the appellate court did note again that this was the 6th time that this firm, and they cited to the cases before, 3 of them had resulted in new trials for tobacco. 1 had not been objected to, so was unpreserved. And then the most recent Kaplan case, where the closing argument errors were held to be harmless in the context of the jury verdict. So what the appellate court here, why did they grant a new trial here in comparison to the week before with the Nazi and 1984 references? Well, what the trial court pointed out here is the closing argument comments achieved their purpose in this case. Plaintiff's counsel asked for $12 million in phase one for compensatory damages. The jury awarded exactly that. Plaintiff's counsel asked for 15 million in punitive damages as to each of the defendants. The jury awarded 15 as to one defendant and 10 million as to the other defendant. And so based on the size of the jury verdict, in this case, the fourth district held that the closing arguments had resulted in had prejudiced the defendants and required a new trial. Now, one other interesting part of the opinion, there was a concurring opinion from Judge Gross. I clerked for way back when. And what Judge Gross noted was the fact that imagery in closing argument should be permitted and that there was nothing inherently wrong. Now, he agreed that the closing argument references here were improper and under the court's precedent required a new trial, but he noted particularly in the context where there's punitive damages that vivid imagery should be utilized or is appropriate and can be utilized. Now, he also noted that in this particular case, in his view, that the closing argument comments were not particularly comprehensible to the jurors. And so they may not necessarily have had any positive impact in terms of, basically to me, reading between the lines, it was Judge Gross trying to say to the plaintiff's bar or to defense attorneys when they use imagery that the imagery may not be effective, and so maybe sound it out, as we said in a prior podcast, maybe sound out what you're going to say and have another voice in your office or, an independent voice, hear what you're going to say in front of the jury, because what you think may sound, great and poetic and effective, it may not necessarily be so on the jury. One other point, the majority in a footnote, they did note, quote, "We do not hold that every metaphor or literary reference is improper. We simply hold that they were improper as used in this case." And so that is the message to take away from the case. And just one other thing, just back to Judge Gross, this is how he ended the opinion. "For what it is worth, I find the 1984 literary reference to be weak and convoluted, hardly the type of argument that would inflame the jurors and cause them to abandon all reason in returning a verdict. Our recent closing argument jurisprudence disrespects the common sense and intelligence of juries, which is the bedrock of the jury system. As Judge Learned Hand wrote almost a century ago, juries are not leaves swayed by every breath." So he was constrained by the precedent of the court, which is why he agreed with the majority here that the defendants were entitled to a new trial. But that was his message, that metaphors and imagery, particularly in cases with punitive damages, should be allowed. Of course, that was not the majority opinion in this case. It was just a concurring opinion from Judge Gross. So any thoughts from you, Jen, on this from a trial attorney perspective?
I'm particularly happy with the concurring opinion, especially just Judge Gross, because who doesn't love Judge Gross? But we're not just sound pieces, right? We're not just a mouthpiece for somebody else when we go up to trial. We're advocates. And how else can you kind of get into the shoes and the mind of a juror without physically doing so or improperly doing so, than using metaphors or using euphemisms that anyone can understand? When you see, especially with the medical case, when most people don't have that kind of knowledge, they don't know what a herniated disc is, when those are commonplace words for us nowadays. So how else can you kind of get into them and, hey, we're on even ground here and we both understand what each other are saying, other than metaphors? So I appreciate that he's saying vivid imagery is good and you're allowed to use it and it's not impermissible, but there is a line. And you should not cross that line. And I guess from my perspective, most of the time the line is pretty bold, pretty clear. Obviously for certain people, especially when this their sixth time around, it's not as clear, or they just like to push the line or go up to the boundaries. But it is particularly important to know that we as advocates and as trial attorneys should not be fearful to go up to the line and to kind of find that even ground with metaphors, with movie references, with book references, with common language, just knowing where the line is.
Right. And that's why I think sometimes it's helpful to have another voice in your office, a partner at home, somebody to read or hear you talk it out loud. I know it's easy for me to say, I don't do closing arguments. Nobody would hire me for that. I wouldn't be very good at it. but have a sounding board, whether
Yeah.
whether
The
you write it out or talk it out.
the amount of times that we think that, like, personally, oh, I have to drop the mic comment. This is how I'm going to end rebuttal. This is going to be great. And then you say it to someone and they're like, where's the rest of that?
Right, right,
All right,
right.
let's go back to the drawing board.
So that is the takeaway from another Engle progeny reversal, as the case may be. Jen, I will defer to you now on the case which is headed up to the Florida Supreme Court on a certified question.
Yeah, and I think this is a good one that we can dive into maybe a little bit more of the specifics on this case, just because I think that's going to have some great implications for future cases going this route. So this is Gulfstream Park Racing Association versus Margaret Volin. This is out of the fourth, so right here in our backyard, even though it's near Broward County, but still our backyard. So in essence, this is a medical bills boardable case. So in this particular matter, Ms. Volin is a Medicare recipient. So a portion or a large portion, it doesn't go into specifics of how much of the for medical bills were paid by Medicare, but a portion was. And her attorneys boarded the full amount of her medical bills, which in this case was roughly 101,000. In addition to making claims for lost wages, loss for future earning capacity, and future past non-economic damages. And there was discussion during the trial, and objections were made by the defense saying Medicare paid for X amount, and this is a contracted amount that was settled upon. So instead of this $101,000 worth of medical bills that they want to board, the lesser settled amount from Medicare is what should properly be boarded. And that is, of course, the issue that we're here for today, because the trial court said, nope, the 101 can go up. And then the verdict came back, and now we're up on appeal. So the defense argues, and successfully argues, one of my now favorite phrases, even though it's not good for plaintiff's attorneys, but it's very compelling, that the court agrees that the amounts of provider bills that the plaintiff never pays are what they're calling phantom damages, and that those are in fact inadmissible. They say in their opinion, in their holding, that the original charge that is no longer applicable is no longer there. If a provider bills 100,000 and then Medicare pays for 30,000, that 100,000 is no longer relevant, and that should not be used and cannot be used to prove that the claimant has suffered any loss by reason of that charge. So then goes into discussion, and this is what the discussion is going to continue going for, is the Jorg opinion, the previous opinion on collateral sources versus Medicare, because medical bills being paid for by private insurance companies, even public insurance companies, is very different than Medicare. Medicare is a government contract. So when you have a collateral source paying, saying that we're going to pay $30,000 out of your $100,000, that is very, very different than Medicare. And the Jorg court has said that that 100,000, when it's being only paid off, or a portion is paid off by a private insurance company or a collateral source, the full amount can be boarded. However, when it's Medicare, that's what we're discussing here. Now, the Jorg court did not discuss about Medicare, because specifically in that case, the plaintiff, Mr. Jorg, Luke Jorg, was not Medicare eligible. So it was not relevant for the court at that time. The court here, which says very clearly that even though there is confusion among boarding Medicare or not boarding Medicare, what they've ended up paying, it's in fact not confusing at all. They say that there's this collateral source rule all the way over here, and that's why we have set-offs, and that's why we've gone the way that we have. But then we've got Medicare. And Medicare, when it is paid, and it is, you've got that certified letter from the government saying you no longer owe 100, you owe 30, you can only board 30. So there is another, other opinions within the second district that says similar things. So the court here in the fourth is saying this is not a confusing matter. This is the law, which of course is now being appealed. And just before I go into the other issue of this case, that portion is up for, the plaintiff has filed a motion for rehearing, a motion for clarification on bonk, so that the entire bench will hear this, and the defense is to respond later this month. So it's still pending. But there's a lot of implications that are going to come with this. And Andrew, you can jump in here too, because that's the essence of that part of the case. We'll get to the certification in just a second, but there's going to be a lot of implications that can come for this, because if you can only board what Medicare has paid, which most times is going to be a significantly lesser amount than what's actually owed, the jury is only going to see what's actually owed. So just to go with the example, if there's $100,000 of medical bills, but Medicare pays 10, the jury's going to see 10. Now, 10 is not saying, I'm not saying by any stretch of the imagination that 10 is not a lot of money to especially jurors that you're going to have in your county. But if they see that you've had the surgery and physical therapy and years of months and months and months of injections and medical doctor's visits and MRI visits, and it only comes out to $10,000. And now you're standing up there saying, well, they are 65, they're Medicare eligible, or they're getting Medicare, but they were going to work for another 10 years and they're going to live for another probably 30 years. How are you going to be able to tell a jury and convince them and still keep your credibility that you should pay all these hundreds of thousands of dollars in future economic and non-economic, when we're showing you a horrendous 2 years in the past equating to $10,000?
Right. And so the case that you mentioned, the second district case, it's the Dial case, which is in the Supreme Court in the briefing stage. And this case, Bolin, assuming it's not, the result is not, assuming the same result after the motion for rehearing, this case is going to head to the Florida Supreme Court. It will probably be on pause while the Supreme Court addresses the Dial decision. But let's presume for the moment, neither of us are in the prediction business. Let's presume this is the law. I mean, it's certainly the law now for all of us at the trial court level. And let's presume that the Supreme Court, what then, right? What do you do? And it presents an interesting issue. One of the things which in my discussions, and I know in your office as well with trial attorneys, is might you decide not to board past medical bills if the amount is small, like in your hypothetical? If you're seeking future medical bills of $500,000, for example. Now, Bolin, there was no request for future medical expenses, but let's say you're seeking future meds of 500 grand, and the boardable gross amount that you can only show the jury for the past is 10 grand, and the medical treatment is the same or similar. Is it going to be advantageous to your client to request the $10,000 in past meds? I would say probably not. Right. And, there's an art to that, if it's 200 grand in past meds, may you decide, well, we can't let this go because our client has this lien amount, it's an art to it. And then the other issue, which is, okay, so let's say that you're going to present the past meds of whether it's 10 grand or 200 grand, and that's the gross amount. Now, can you mention to the jury why you're seeking? Let's say you had a past neck surgery and you can only board 4 grand for it and $200 for the past MRI, but the future neck surgery is 40 grand and the future MRI before that neck surgery is 2 grand. Can you explain to the jury, look, we're asking for 40 grand for the future neck surgery, even though we're only asking you to reimburse us 4 grand for the past? How do you adequately explain that to the jury? The only way you can tell that to the jury is to introduce insurance
Medicare.
issues. Right. And of course, there's a whole line of cases that you can't introduce collateral sources except when the door is open. Except when the door is open. And the question then is, if you can only board 10 grand in past meds, or you can only board the gross amount, does that open the door to allow you to mention the reason why it's low? And then, of course, do you even want to do that? Do you want a jury to tell that?
You take that a step further. In this case, they're very clearly drawing the line in the sand between Medicare and collateral sources. So if you're not allowed to talk about collateral sources as the law stands now, then there's an argument that you could talk about Medicare and say, hey, it's only 4 grand because of Medicare. But then you have the flip side of that with collateral sources, if you have private insurance when the accident happens or the incident occurs or you get the injury, and you have this incredible insurance to pay for your surgery today, but you're going to need surgery again in 10 years and you no longer have that job, so you no longer have that insurance, you have an argument there that, okay, so collateral sources are not going to pay for it. You're not going to not be Medicare eligible. Once you hit 65, you're there, you're in the game. So there's really no strong argument you can make that if it was 4 grand last time, how are you going to argue that it's not going to be 4 grand next time?
Right. And
And I think that, go on.
no, go ahead, please.
Well, I was going to say, and then furthermore, when you're talking about all the different damages that you're asking for from a jury, it's not just medical bills. It's, and especially in this case, it's lost wages, it's loss of future earning capacity. In this case, it was past non-economic, but we all know that a great percentage of our cases are successful on future non-economic. And I think that there's some kind of strategy there, or at least there's some kind of mental seed that you're planting that if your boardables are $10,000, how could a jury ever think that, like, okay, well, if this horrendous accident with these surgeries and these injections and these years and years and years worth of PT and whatnot only resulted in $10,000 of medical bills, they couldn't have lost that much work time. Or if it was only 10 grand, then they could probably keep on working. And if it was only 10 grand, how could it have affected their life that much? So how are we going to expect a jury, or how would we even think that a jury can write 10 grand in the first slot and anything more than that in the remaining questions?
And years ago, there's a case from the fourth district, Durst versus Hen, which I won that case. And in that case, the plaintiff had settled with one defendant, and the trial court had prevented and had paid off some of their medical bills. This is not a Medicare situation, but had paid off some of their medical bills from that settlement. And then the trial judge prevented the plaintiff from showing the full amount of the medical bills at trial. So the fourth district agreed with me that the plaintiff should have been entitled to board all medical bills, not the reduced amount. The plaintiff had earned something in reducing the amount of the medical bills from the settlement. But what was interesting in my briefing, and this is a long time ago, this is about 2010, I argued that one of the ways the plaintiff had been harmed by not being able to board the full amount was because the jury's determination of all elements of damages, not just economic damages, but non-economic damages, could be influenced by the amount of the boarded medical bills. Now, we saw that play out. Fast forward here to, and the fourth district didn't address my argument in its opinion. Fast forward here to Volin. After the trial, or after the appellate court concluded that the trial court had erred and that the plaintiff should only have been allowed to board the gross amount of the medical bills, the fourth district held that the defendant was entitled to a new trial on all damages. So not just past medical bills, but also, as you mentioned, past earning, past lost wages, future earning capacity, past non-economics, and future economics. And so, although the fourth district didn't explain how the defendant had been harmed in these other elements of damages, I think it's safe to assume that the appellate court felt and agreed with the defendant, as you were saying, that a jury's determination of all elements of damages, we're not inside the jury room. It's not a science how they decide damages, but they can equate different elements of damages based on the amount of your economic losses.
I mean, the jury instruction it does say, when you're talking about non-economic, that there is no calculation. So we're giving them instructions to go to the back and say there's no mathematical equation, there's no A plus B equals C, there's no numbers there, but then we're asking them to award numbers. And the only numbers they're going to see are these reduced numbers. And so I think it clearly does the attorneys a disservice, but it does, I believe, the client, the plaintiff, a huge disservice, because it's belittling what they've gone through. And I mean, at least in my experience with myself and my firm, when we are going to trial, it's not because someone, stubbed their toe. Like, these people are injured, and we're trying to compensate them for their injuries, not just now, but for the long future that they hopefully have. And if I'm showing boardables of $10,000, just for easy math, and we're not able to give any other number to bring back to the jury with them, and then they're going to go back there and say, okay, there's no calculation, but we have to give a number, and the only number we have is this nominal amount. It's going to be tough, I think. And I think what's even further is that we're just talking Medicare. I feel like there's a logical, hopefully not, but there's a logical next step. It's like, okay, well, if we're not able to show the full amount, but just the agreed settled amount for Medicare in Medicare cases, What if it's not a Medicare case? And now we're going to expand this to collateral sources in totality. And we're not allowed to talk about setups. We're not allowed to talk about how much the initial money was. And now we're going to be seeing a lot more $10,000. I think that's going to be very, very difficult.
I certainly think that people will try and push that argument. Now, there are definitely distinctions between Medicare and health insurance. The decision here, Volin didn't talk about how the plaintiff became Medicare eligible. But of course, most people who become Medicare eligible pay into this. You and I both pay Medicare as employees of our firms. And obviously, if you have health insurance, you may pay premiums. I talked about the Durst versus Hen case where the plaintiff had achieved a benefit in settling the case with one defendant. And so there's definitely differences, easy ways to distinguish Medicare, but your point is very well taken, that there will probably be efforts to apply the reasoning of this case and the Dial case to non-Medicare cases. So everyone will all have to stay tuned for that. In the meantime, of course, when you're at the trial level, as you head to trial, it's my advice, but it's just my opinion. One, obviously, you can't lead a trial judge into error. And so the trial judge is bound by these decisions. But you realize from what happened in Volin that if you somehow can persuade a trial judge to board all your medical bills, and you're going to end up with a retrial on all damages if an appellate court holds to the trial court. So I think being safer is the better approach here to take.
Absolutely. Avoiding that line.
As these cases head up to as Dial and Volin, presumably Volin is intact after the rehearing process, head to the Supreme Court. So I'm just going to, one other case we're going to talk about, or I'm just going to briefly talk about here at the end, and it's only because of this theme of misconduct, which we've talked about in a couple of our podcasts, and I know I mentioned the opening closing argument case, but this case from the 5th District, Safepoint Insurance Company versus Hallett, 5D 20-206. Now, this is for me, and I know for you, Jen, we both found the decision boring because it's a property insurance case with examinations under oath. And I'm not going to bore our listeners by going into the facts of the case, but what's notable for all of us is the appellate court did reverse the summary judgment which had been granted to the plaintiff. So the insurance company won the appeal, but the insurance company's defense attorney was called out pretty heavily for trial counsel's conduct during examinations under oath, which are, I guess, akin to depositions. And so I'm just going to point out what the appellate court had to say about the defense attorney here. It's in footnote 1. Now, I'm not going to mention the defense attorney by name. I don't know the defense attorney. I'm not here to disparage anyone, but defense attorney represented Safepoint at the pretrial and trial proceedings. The appellate court then explains the purpose of an examination under oath. Well, one must read the entire examination to appreciate his behavior fully, defense attorney's behavior. The first 30 pages of the first examination alone contain multiple instances of unprofessional conduct. Defense attorney repeatedly lectured and questioned the plaintiff, who had a high school education, on the insurance policy. A defense counsel called the plaintiff, quote, rude, disrespectful, confrontational, and defensive. The defense attorney referenced how long he had been practicing law and repeatedly highlighted his past career as a homicide prosecutor. Does that sound like something that serves any meaningful purpose other than to try and intimidate?
Well, we all know those people that are like, listen here, I have been practicing since you were in diapers. It's like, okay, that's serving nothing to nobody.
Right, and it gets worse. Throughout all 3 examinations, so there were 3 examinations under oath, his behavior towards opposing counsel was also unprofessional. He called opposing counsel irritating, offensive, belligerent, snarky, a jerk, a very nasty person, a setup artist, and an ass. He didn't say asshole, he said an ass, okay? He informed opposing counsel that he was, quote, not in South Florida, was not in Miami, and that Hernando County judges are really going to be interested in your style. And then he emptied up further. He encouraged opposing counsel to file a bar complaint. The quote was, file a bar complaint, sport. And he described the plaintiff's counsel's objections as grievable. Taken as a whole, defense counsel's repetitive and argumentative examinations illustrate he was more interested in making the process as long as painful as possible, rather than gathering information about the plaintiff's claim And then the Fifth District noted in this footnote that the Second District last year twice called out this defense attorney for unprofessional behavior. And then in 2021, this footnote notes the Florida Supreme Court reprimanded this attorney for unprofessional questioning of witnesses and treatment of opposing counsel. The Fifth District footnote notes, we have recently noted misrepresentations he made to the trial court in another case. And then finally, the Fifth District referred this attorney to the Florida bar. And so this is an example where our appellate courts, we've talked about in recent opinions, they've told trial judges, implore trial judges to be more vigilant and to monitor these things at the trial level. This is a situation where it necessarily didn't yield itself to at the trial level, because I suppose plaintiff's counsel could have filed a motion for sanctions, but it certainly ripened at the appellate court, and the appellate court did not have to address any of this in its footnote whatsoever. This is essentially, you want to call it dicta.
Yeah.
There was a legal issue regarding the property insurance and whether the insurance company had waived a provision, and that's for the property insurance geeks if they want to review the opinion. But for purposes for all of us, here's an example where the appellate court called a spade and reported this attorney to the bar. They noted where he'd been called out, and if
I commend them.
Right.
That's the nature of our business. We have to self-check ourselves. And if someone, like you said, calling a spade, if someone is acting out and it's not their first time, especially if it's not their first time and they're just not getting it, no matter how many years of law they've been practicing, you got to do what you got to do. And I commend them for doing the right thing.
So Jen, as a trial attorney, what do you do? Just maybe anybody, what do you do in that situation when you're on the receiving end of a defense attorney? Well, it doesn't have to do with him being a defense attorney. Opposing counsel who conducts themselves. What are you supposed to do? Like, what do you train your young associates? What have you, your partners? What do you do there?
Well, you asked two different things there. What are you supposed to do, and what do I actually do? What you're supposed to do, and this is, I tried to practice this, and I do this not just in my professional life, but my personal life. I mean, if I'm in a fight with my sister or my friend or my husband or whatever, and things are getting hot, the best way to take the steam out of it is just to be calm. And usually that kind of irritates the other person more. But if you are doing something wrong, if you are outwardly, especially at this attorney in the deposition, that's all being recorded, and you are acting out and being inappropriate, I'm not going down to that level. The best thing I could do is just stay quiet. It's like what your parents taught you when you had a bully in school. You don't do what they're doing. You just don't give them that satisfaction. And do I always do that? No. Do I wish I did? Yes. But I've also found professionally, the more I get with other people, when other people are being volatile like that, it's gotten easier for me over the years to just, okay, thank you, sir. Thanks, counsel. Moving on. Usually does not calm them down, but it keeps me calm. And if I need to move for sanctions thereafter, I will. But that's the best way. Why would you match someone's bulliness with more bulliness?
Right. You just go down to their level, and then of course it makes it hard for you then to seek relief.
Right, like just as bad.
Judge, right, because it's just two people fighting with each other rather than. I think that's a really good piece of advice to be the. I mean, first off, it's the nature of how you are, but I just think in general, just for the benefit of your client or all of our clients in trying to take the high road, but it's easier said than done.
Oh,
obviously.
I think that's a very good point as well. Is that we all have clients. I have no problem with any attorney that I'm going against. I mean, we all have a job to do. Just because they raise some defense that I think doesn't hold water, they have a job. And just like I have a job. So by getting personal and calling someone a jerk, etc., your client sitting there or going to be reading this deposition transcript and saying, what the heck? It's not going to, certainly not helping them.
No. So that is a good and proper message sent from the appellate court, to this defense attorney here, this defense attorney's firm. The client, obviously, it's an insurance company, and of course, a lot of insurance companies, they have a pick of different choice of defense attorney, defense firms where to go to. And so if I were the adjuster at Safepoint Insurance Company, I may think twice about using this firm for future cases, right? And that message sometimes can only come from what? A trial court's opinion or an appellate court's opinion, because our clients don't necessarily know what's going on, can read it, can understand it. They've all got different cases and files. So with that, we will conclude this edition of the Florida Appellate Review. As we've noted previously, if you'd like to be a guest on any of our podcasts, please let us know. You can let Jen, myself, or Jeff know. Our podcasts are anywhere on any of your favorite streaming places. We've got the Palm Beach County Justice Association podcast and also my podcast at Florida Appellate Review. But the case law updates are on both networks, on our social media pages. If you'd like to be a guest to not talk about cases, but you just like to be a guest, if you've got an interesting client case of yours, service to the community, just let us know. And we are looking forward to expanding beyond these case law updates in the future. So thank you so much, everybody, for joining us, and we will see you soon. Take care.